it pleases Your Excellencies, my name is Ang Cheng Hock, and I appear with my co-agent Ms. Jayanti Sudanati. We act for the applicant state of Fredonia in this matter. Your Excellencies, this case concerns the rejection by the respondent state Balboa of the claims of refugee status of two groups of persons presently detained in Balboa. The first group is the Pankhurst family from Draconia, and the second group, Your Excellencies, is a group of several hundred Laborians. The applicant state Fredonia is a sympathetic third state concerned about the plights of the Pankhursts and the Laborians. Fredonia has offered to grant these people permanent asylum. These people have expressed their willingness to go, but Balboa has refused to let them go. Your Excellencies, Fredonia has thus applied to this court, seeking a declaration from this court that Balboa is obliged under international law to transfer these persons from Balboa to Fredonia.
Agent, what does give you a right to have a standing in this court to seek that redress?
Your Excellencies, we submit that Balboa has breached the customary law of human rights by keeping the Pankhursts and Laborians in prolonged arbitrary detention, and also by committing other gross and consistent violations of the internationally recognized human rights. Therefore, Your Excellencies, relying on American restatement and relying on this court's decision in the Barcelona traction case, we submit that Fredonia is an injured state because Balboa has breached the customary law of human rights.
In that particular case, did this court hold that without showing a special legal interest, you could invoke the court's jurisdiction and have standing?
Well, Your Excellencies, in para 34 of the court's judgment in the Barcelona traction case, the court pointed out there are certain obligations, termed obligations erga omnes, which are so fundamental for the protection of human rights and fundamental freedoms that all states have an interest to enforce, Your Excellencies. We take it from this passage, Your Excellencies, that all states have a legal interest when erga omnes obligations are breached. We also rely, Your Excellencies, on the writings of eminent publicists, as shown in the American restatement and also in the International Law Commission draft articles on state responsibility, that show that when a state has breached the customary law of human rights, all other states have a legal interest to enforce such rights.
Enforce in the International Court of Justice?
We submit, Your Excellencies, although there has been no judicial pronouncement from this court specifically allowing a state like Fredonia to assert erga omnes obligations before this court.
But Agent, there is a case. I did not sit on that court, but my brothers and sisters did. And in that particular case pertaining to Southwest Africa, this court did not give Liberia and Ethiopia the right to come before the court and have standing. Is that right?
Yes, Your Excellencies. In that case, Your Excellencies, this court held that Liberia and Ethiopia had failed to show they had a special interest or legal interest that had been injured. However, Your Excellencies, that case was decided in 1966. It submitted, Your Excellencies, that in 1970, the court recognized that there is, however, an obligation, certain obligations, erga omnes, which are so fundamental that all states can have a legal interest. And this is a step away from the position taken by a majority of the court, a 7-6 decision of the court in the Southwest Africa cases, Your Excellencies.
Mr. Ang, in the event that this court should find that an obligation erga omnes is not sufficient standing, is it your position that your case might have been strengthened if the Pankhursts and the Laborians were Fredonian nationals?
That would be correct, Your Excellencies.
So this case, to some extent, hinges on the nationality of the parties for whom you seek relief.
No, Your Excellencies. Yet, Your Excellencies, the general rule in international law is that under the principle of nationality of claims, only the aliens, when aliens have been injured, only the aliens' national state can bring claims on behalf of such aliens to exercise diplomatic protection on behalf of such aliens. However, Your Excellencies, it's submitted that the concept of obligations erga omnes represent an exception to the rule of principle of nationality of claims.
And Agent, there is an erga omnes obligation here. Is that your claim?
We submit, Your Excellencies, as is demonstrated by the American Restatement on Foreign Relations Law.
Is that an authoritative statement for this court to be bound by?
No, Your Excellencies. It's submitted that it represents the writings of eminent publicists, which forms a subsidiary means for this court to determine law under Article 38 1D of the statute of this court.
If I could jump in here with one question as a follow-up on the erga omnes argument. If all states have an interest in enforcing erga omnes obligations, what right do you purport to represent all states? By what right do you come before us on behalf of the entire international community?
No, Your
And would all other states be in a similar position so that we might then hear similar erga omnes arguments from all other states?
Your Excellencies, it's submitted. The concept of erga omnes obligations are such that all states have a legal interest, and Fredonia can assert a legal interest as an individual state and not on behalf of the international community as a whole, Your Excellencies. Furthermore, Your Excellencies, this is a case where Fredonia is only seeking a declaration as to the rights of the Pancas and the Laborians in international law, and that is not, we are not, Excellencies, seeking reparation from the state of Balboa, and this strengthens our position, Your Excellencies, that we can assert an erga omnes obligation. Your Excellencies, this is also further reinforced by the fact that Pancas and Laborians are refugees, as will be fully explained by my co-agent.
Mr. Ang, you mentioned the nationality of claims. Could the case not be taken out of an exception into the mainstream by Fredonia recognizing the Pancas and the Laborians as Fredonian nationals? We could have made them citizens of Fredonia.
Your Excellencies, that may be so. However, we have received no instruction from our government that that is to be the action of the government of Fredonia. And on the facts as presented today, Your Excellencies, the government of Fredonia has not done such a thing, and the Pancas and Laborians have not shown that they're willing to take up the nationality of Fredonia. Your Excellencies, I shall now briefly outline the issues I shall be dealing with respect to jurisdiction.
May I take another moment with you, Agent?
Yes, Your Excellencies.
Assume that there are boatloads of asylum seekers leaving a country, and another country intercepts them on the high seas, takes them back to their own country of origin. Would Fredonia be able to invoke this court's jurisdiction and say that there is a standing because there is an erga omnes obligation on the part of the state not to take them back to their state of origin?
Well, in that case, Your Excellencies, it would depend on the circumstances of that case, whether or not the state which intercepted the boat people or the busload of people, whether that state had breached an erga omnes obligation or had breached the customary law of human rights.
Which erga omnes obligation is being breached here?
Your Excellencies, we submit, as my co-agent will fully explain, that the Balboa has kept the Pancas and the Laborians in prolonged arbitrary detention, and we submit that that is a breach of the customary law of human rights, which is an erga omnes obligation. Furthermore, Your Excellencies, as will be again fully explained by my co-agent, Balboa has subjected the Pancas and the Laborians to gross violations of their fundamentally recognized human rights, such as the right to family life and such as the rights of the child. Your Excellencies, I shall now outline my submissions on a question of jurisdiction. Your Excellencies, Fredonia's position on jurisdiction is that we do not deny that Balboa is entitled to rely on the two reservations in our optional clause declaration. One is the time reservation, and the second is a national jurisdiction reservation. However, Your Excellencies, Fredonia takes the position that these two reservations do not operate on the facts of this case to exclude the court's jurisdiction. We therefore ask the court to declare that it has jurisdiction to hear this case. I shall deal first with the time reservation, Your Excellencies. Your Excellencies, there is a time reservation in Fredonia's optional clause declaration. This time reservation excludes all disputes arising prior to 4th of June 1993. Now, Balboa is entitled to invoke this time reservation under the principle of reciprocity. However, Your Excellencies, the dispute in this case only arose in mid-July 1993, and therefore the time reservation does not exclude the court's jurisdiction.
Isn't the time relevant when she was denied her refugee status?
Your Excellencies, it is submitted that the relevant time in this case, in the light of the reservation inserted by Fredonia, is the time mid-July 1993 when Fredonia demanded that Balboa transfer these persons to Fredonia, and Balboa refused to do so. Your Excellencies, in the Permanent Court of International Justice case of Mavromatis Palestine concessions, the Permanent Court held that a dispute is defined as a disagreement on a point of law or fact, or a conflict of legal views between two states.
Are we bound by that decision, Mr. Agent?
No, Your Excellencies, the decision of this court is only binding on the parties before the court. However, Your Excellencies, the definition of dispute in the Mavromatis Palestine concessions case has been applied by this court in several other cases, for example, in the rights of passage case. Your Excellencies, in this case, it is only in mid-July that Fredonia first demanded that its people be transferred over to Fredonia. And it's at this point in time, Your Excellencies, that Fredonia and Balboa reached opposite sides as to the rights and obligations under international law. And it's at this point of time, Your Excellencies, that a dispute first arose between Fredonia and Balboa. Your Excellencies,
Mr. Agent, is it your position that the matter of refugee status determination falls in the area of international law or domestic jurisdiction?
we submit, Your Excellencies, that the question of refugee status is one of international law.
But it plays itself out in the domestic arena, does it not?
Yes, Your Excellencies, the state is entitled to determine, based on the criteria, whether or not a person is or is not a refugee.
Would it not have been more appropriate for your client state to pursue local remedies and sue in a Balboan court for the release of the Pankhurst and the Laborians?
Your Excellencies, we submit that as Fredonia and Balboa are sovereign states, Fredonia is not obliged to pursue local remedies within the state of Balboa in order to exhaust these remedies before they are entitled to bring this claim against Balboa.
It doesn't quite answer my question. They might not be obliged, but were they precluded to pursue local remedies in Balboa?
Your Excellencies, on the facts, it is unclear whether or not such local remedies did in fact exist. However, Your Excellencies, it is clear from the facts that a final determination had been made as regards to Hilary Pankhurst's non-refugee status.
In what form has this final determination been made, Mr. Agent?
Your Excellencies, on the fact, it is stated that it is merely stated that Hilary's initial determination that she is not a refugee by the Ministry of Immigration was later confirmed by a final determination, and there is insufficient facts, Your Excellencies, to indicate whether there are or there are not such local remedies to further exhaust before Fredonia has standing to seek a declaration against Balboa. Your Excellencies, in the Interhandle case, in the decision of this court pointed out that the actual dispute must be distinguished and not be confused with the facts and situations giving rise to such a dispute. Now, the actual dispute in this case, Your Excellencies, is the demand of the Pankhurst and Laborians to be transferred and Balboa's refusal to transfer them. Facts and situations giving rise to this dispute is the determination of the Pankhurst and the Laborians as not being refugees. Your Excellencies, the respondent has relied in his written submissions at page 6 on the Electricity Company of Sofia and Bulgaria case to show that since the facts and situations arose prior to 4th of June 1993, this court is precluded to have jurisdiction to determine this case. Well, Your Excellencies, we submit that this is clearly a wrong and untenable application of the case of Electricity Company in Sofia and Bulgaria. That case, Your Excellencies, dealt with a double exclusion formula, a temporal reservation which excluded disputes arising before a critical date, and also disputes where the facts and situations arose before that critical date. Your Excellencies, in this case, Fredonia's temporal reservation only has a single exclusion formula. It only excludes disputes arising before the 4th of June 1993 and not disputes where the facts and situations arose before the 4th of June 1993. Therefore, Your Excellencies, the temporal reservation in this case cannot exclude the court's jurisdiction. Your Excellencies, I shall deal next with the national jurisdiction reservation. Fredonia has a national jurisdiction reservation in its optional clause declaration. This national jurisdiction reservation allows Fredonia to exclude from the court's jurisdiction matters essentially within the national jurisdiction of Fredonia as determined by the government of Fredonia. we do not dispute, Your Excellencies, that Balboa is entitled, under the principle of reciprocity, to invoke this national jurisdiction reservation. However, Your Excellencies, it is our position that this national jurisdiction reservation cannot exclude the court's jurisdiction in this case. Your Excellencies, at this juncture, it must be pointed out that the respondent state relies heavily on the case of certain Norwegian loans, the 1957 decision of this court. In that case, Your Excellency, this court allowed Norway to rely on a French national jurisdiction reservation in a French optional clause declaration to automatically exclude the court's jurisdiction. And therefore, they cite this case for the authority that Balboa is entitled to rely on the national jurisdiction reservation in Fredonia's optional clause to automatically exclude the court's jurisdiction. We have 3 points to make with respect to that case. First, in that case, France never challenged the validity of such a national jurisdiction reservation. France was glad to allow Norway to rely expressly on the face of the national jurisdiction reservation. Secondly, Your Excellency, the court specifically refused to declare on the validity of such a national jurisdiction reservation, or if it was valid, how it was to be applied. And thirdly, there is a strong dissenting judgment by George Lauterpacht, pointing out that such national jurisdiction reservations are contrary to Article 36, Clause 6 of the statute of this court. Article 36, Clause 6 of the statute of this court preserves the power of this court to determine in every case whether or not it has or it does not have jurisdiction.
Agent, what did this court hold in that case?
Judge, in the case of Norwegian loans, Your Excellency?
Did it not accept the reciprocity
Yes, Your Excellencies.
argument?
They accepted the reciprocity argument, Your Excellencies, but the court specifically did not deal with the issue of whether such a national jurisdiction reservation would be valid. And it was pointed out by Judge Lauterpacht, as well as by many eminent writers in the 1950s and 1960s, such as Sir Humphrey Waldock, Sir Robert Jennings, that such national jurisdiction reservations contravene Article 36, Clause 6 of the statute of this court.
So you're arguing that your government's reservation is invalid?
No, Your Excellencies, we submit, as suggested by many contemporary writers, such as Sir Gerald Fitzmaurice, such as Shabtai Roseanne, and such as Ibrahim Shihata, that such national jurisdiction reservations must be read in good faith. If read in good faith, this court would still have the power under Article 36, Clause 6 to determine whether or not it has or it does not have jurisdiction. The test for this court to apply is to ask whether Balboa has determined in good faith that this dispute is over a matter which is essentially within its national jurisdiction.
Mr. Ang, if I understand the thrust of your argument correctly, then you're saying that Judge Lauterpacht's dissent has entered customary international law. Is that the gist of it?
No, Your Excellencies, there is no state practice or opinion juris to support that such a principle has become part of customary international law. However, Your Excellencies, we have the writings of eminent publicists and also the decision of this court in the Nicaragua case, where this court held that the principle of good faith plays an important role in the system of engagements that constitute the optional clause system. Therefore, Your Excellencies, we submit that Balboa has to make a good faith determination in invoking this national jurisdiction reservation. And our position is that Balboa has not invoked it in good faith. Your Excellencies, this case concerns the determination and treatment of refugees. It concerns the breaches of customary law of human rights. It also concerns Balboa's obligation as a signatory to the Child Convention. These are all matters of international law, Your Excellencies. Therefore, Balboa cannot determine that this issue is essentially within its national jurisdiction. Your Excellencies, I see my time is running up. I shall now briefly conclude my case. Your Excellencies, our position is this, that the national jurisdiction reservation cannot exclude the court's jurisdiction because Balboa has not invoked it in good faith. Our position on the time reservation is that it cannot exclude the court's jurisdiction. Your Excellencies, my time is up. May I just complete my sentence? Thank you. Your Excellencies, our position on the time reservation is that the dispute clearly arose in mid-July 1993, and so the temporal reservation cannot exclude the court's jurisdiction. And finally, on the question of standing, which I first started off, we submit again that the Balboa has breached the customary law of human rights. And because this is so, Fredonia is a state with the necessary standing and the interest to seek a declaration against Balboa. Your Excellencies, if Your Excellencies have no further questions, I have no further submission.
Can I just put one question to you?
Yes.
This is just an idea, and it's possibly a novel one. How would you respond to the argument or the view that the Refugee Convention has become customary international law? I take it that is the argument that's going to be followed by your co-agent.
That is correct.
In the 51 Convention and in the 1967 Protocol, there is a requirement to make reference to this court in the event of a dispute. Could you argue that as the substantive provisions of the Convention have become customary international law, so have the procedural?
Well, Excellencies, we would say that the procedural sections clearly demonstrate any doubts, clearly remove any doubts that the question of the determination of refugee status is one of international law. However, Your Excellencies, on the question of whether this court has jurisdiction to hear claims on questions of refugee law, that would really depend, Your Excellencies, on whether there has been prior consent to the court's jurisdiction or whether the two states have agreed to specially hear the matter before the court.
Yes, but I was just meaning that if you accept that the Convention has become customary international law, then are you saying certain provisions of the Convention have become customary international law, or have all the provisions of the Convention become customary international law, and therefore you are obliged to refer to the state in the event of any dispute?
Well, yes, Your Excellency, that is one possibility. If Your Excellencies have no further questions, thank you.
May it please the Court, my name is Jayanti Sadanandan. I will be addressing the Court on the merits of this case. Your Excellencies, this dispute raises two questions which hold great significance to the international community: the rights of refugees and the obligations of a state of first asylum. On a more immediate plane, this Court's decision today will determine the plight of a group of persons who have been detained in Balboa, the respondent state, for many months now. The relief we are seeking is twofold. We ask this court to declare first that Balboa has failed to protect the internationally guaranteed rights of the Pankhursts and the Laborians, and secondly, to declare that Balboa is obliged under international law to transfer these persons to Fredonia. In order for this relief to be granted, this court must answer three questions. First, whether the Pankhursts and the Laborians are refugees. Secondly, whether Balboa's treatment of these persons is in accordance with international law. And thirdly, whether international law obliges Balboa to transfer these persons to Fredonia. Our position with respect to all three issues is simply this: we submit that the Pankhursts and the Laborians are refugees. As refugees, they were entitled to certain rights under international law. At the same time, customary international law imposed an obligation on Balboa to protect these rights. Balboa failed to do so. International law therefore obliges Balboa to transfer these persons to Fredonia.
Agent, how does that third question follow from the second? That these people should therefore be transferred to Fredonia?
Your Excellency, our position is that Balboa was under an obligation to protect the rights of these persons, namely the right to family life, the rights of the children, and the right to be free from prolonged arbitrary detention. Balboa has violated these rights, and in these circumstances, because Balboa is under an obligation to find a durable solution for the refugees, and because these persons possess the right to leave Balboa, Balboa is under an obligation to transfer these persons to Fredonia.
And that assumes that the point that the co-agent began with, that the convention and the protocol have become customary international law, right?
Yes, Your Excellency.
Would you kindly enlighten me a little more about the uniformity, consistency, opinion juris, all those elements that are required?
Yes, Your Excellency. Our position is not that the entire convention and protocol have passed into customary international law. Our position is simply that the substantive provisions in the convention, and on the facts of this case, we are concerned with two provisions in particular, namely the convention criteria as regards refugee status itself, Article 1, and the non-refoulement provision, Article 33. And we submit that these two provisions have passed into custom. And to answer your question, Your Excellency, as regards the convention criteria, we submit that the fact that this provision is of fundamentally norm-creating character, and the fact that there has been widespread and representative participation in this convention from all 5 continents, and the fact that there is both state practice and opinion juris, that on all these grounds, this convention provision has passed into custom.
Aren't there many states that do not comply with the provisions of the convention?
They may not comply with all the provisions in the convention, Your Excellency.
No, these two, because both states that are concerned with refugee issues, and this court doesn't need to take judicial notice of them, but I have seen that there are plenty that have not ratified the convention, that are not signatories to the convention, and obviously Balboa has not ratified the convention.
That is true, Your Excellency, but our position is that these provisions have passed into custom because even the practice of the most seriously affected non-party states is consistent with our submission. For instance, Your Excellency, with respect to the practice of Asian states, most of whom are not parties to this convention, it appears from the practice of these states that they have applied the convention criteria to determine whether persons are or are not refugees.
Can you name me 3 states, Madam Regent?
Yes, Your Excellency, Thailand, Malaysia, and Indonesia. And this is borne out by the ministerial statements made by the governments of these states at the 12th ASEAN Conference in 1979. Your Excellency, our position is that the convention criteria has passed into custom and that the Pancasts satisfy this convention criteria, and as such, that they are refugees. With respect to the Laborians, we agree that they do not come within the convention criteria, but our position with respect to the Laborians is that there is a second category in international law, a humanitarian refugee category that has evolved out of the practice of states, and that the Laborians satisfy this category, and as such, they are entitled to refugee status.
Madam Agent, you made a remark that the rights of the Pancasts and Laborians had been violated. What are the indicia of that? What types of things did you say show that their rights have been violated, other than the fact that they've been in detention? And which rights would you say have been violated?
To answer your last question first, Your Excellency, we submit that 3 rights have been violated, namely the right to family life, the rights of the children, and the right to be free from prolonged and arbitrary detention.
And where do you find those rights?
These rights, Your Excellency, we submit are basic human rights which are available to all individuals. With respect to the right to family life, we submit that this is a basic human right which is available to refugees. And this is borne out by the fact that this right can be found in various international instruments, such as the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the American Charter on Human Rights, the African Charter on Human Rights, and the European Convention on Human Rights. With respect to the rights of the children, our position is that the 1989 Convention on the Rights of the Child has passed into custom, so as to bind has passed into custom. And with respect to the right to be free from prolonged arbitrary detention, we rely on 2 authorities. First, the U.S. Restatement, Section 702 of this restatement, which states that the right to be free from prolonged arbitrary detention is a basic human right. And we also rely on the decision of this court in the U.S. hostages in Tehran case, where the court held that persons are entitled to the right to be free from interference with their... Yes, Your Excellency.
Just to let you go through.
I'm
I
sorry.
wanted to know where, you said that it had passed into customary law, the Convention on the Rights of the Child. I wanted
Yes,
to
sir.
know what you based that on.
We base our contention on the unique circumstances surrounding this convention. We urge this court to take note of the fact that this is the first United Nations Treaty on Human Rights which has been ratified by which has come into force, I correct myself, Your Excellency, which has come into force in the shortest span of time. For instance, Your Excellency, the text of this convention was adopted in 1989, and it came into force the following year, and relying on the U.S. restatement, with Section 102 of this restatement, which states that widespread and representative participation in a convention and widespread and representative ratification of this convention can result in the passing of a convention into custom. We rely on this proposition and submit to this court that the fact that more than 135 states are parties to this convention within a short period of time, that this has resulted in the substantive provisions of this convention passing into custom.
Agent, excuse me, to follow up along that same line. That's all very well and good, the argumentation dealing with the rights of the child, but a right to family life. Could you educate me exactly where that comes from, other than some broad language? What does that mean in your own terms? Does it mean everyone has a right to have a family, a right to maintain a family, even during separations for how long, under what circumstances? Is this right, which is a very strong word, obviously, is that defined in any meaningful way?
Your Excellency, our position with respect to the right to family life is that in this case, Balboa was under an obligation to ensure the protection and the preservation of the family unit, which is the fundamental unit of society. This right can be found in the following international instruments, Your Excellency, namely Article 16.3 of the Universal Declaration of Human Rights, Article 23.1 of the 1966 International Covenants, Article 10 of the International Covenant on Economic, Social, and Cultural Rights.
Do those instruments go any further than the general description you just gave about protection and preservation of family life?
No, Your Excellency. All they state is that a state should protect and preserve the fundamental unit of society, which is the family. And we also pray and aid the statements made by the Office of the UNHCR to the effect that states, in circumstances when dealing with refugee problems, that states should always ensure the protection and the preservation of the family unit.
Madam Agent,
Go ahead.
Madam Agent, your learned opponents might well state that they've exactly protected the elements of that family by keeping the Pankhursts safe and by putting Emily into a foster home away from the rather squalid environment in which she might otherwise have lived. How do you respond to that?
And Madam Agent, just to add to that, it's simply a temporary measure, isn't it?
To respond to Your Excellency's question first, Your Excellency, we have 2 points to make in answer to your question. First, Your Excellency, it cannot be argued by the respondent state that it was in the best interest of the child to be taken away from its parents, to subject it to the emotional trauma of separation, and to place them in a totally alien environment where the foster parents did not even speak the native language of these children. And we submit that the justification that they have relied on, namely the best interest of the child, does not avail them in this case. With respect to Your Excellency's question, we submit that the actions of the Balboan authorities cannot be justified, since Balboa's separation of the family unit was not reasonable in the circumstances of the case, and it was not necessary in the circumstances of the case. There is no evidence to indicate why Balboa should separate the husbands and wives, and why they should take away the children from their parents and place them in an alien environment. And in the absence of any evidence to indicate or to justify their actions, we submit that this court cannot find that Balboa has acted in accordance with international law.
Well, one such argument might be that in the interest of state security, the parties should be kept in secluded quarters until such time that a permanent solution might be found. You also spoke of a prolonged incarceration or prolonged safeguarding of the Pankhursts. They have not been all that long yet, have they?
On the contrary, Your Excellency, they have been there for about a year now. And
The Laborians have been, not the Pankhursts.
the Laborians have been there since last May, Your Excellency, and it has been about a year, slightly less than a year, Your Excellency. And with respect to the Laborians, they have been there for nearly 2 years, Your Excellencies, and we submit that this does amount to prolonged arbitrary detention in circumstances where there is no justification for detaining refugees and limiting their freedom of movement. Your Excellencies, our primary submission is that these persons are refugees. I shall establish the refugee status of these persons, Your Excellencies. Dealing first with the Pankhurst family, we submit that these persons are refugees because they satisfy the Convention criteria, that is, the criteria found in the 1951 Convention relating to the status of refugees, read with its 67 protocols. This Convention criteria requires an applicant to satisfy 2 elements. First, the applicant must possess a well-founded fear of persecution. Secondly, this fear of persecution must be based on one of the enumerated grounds in the Convention definition. We submit that with respect to the Pankhursts, both these elements are satisfied. Dealing first with Hilary Pankhurst, Your Excellencies, we submit that the actions of the draconian authorities do give rise to a reasonable likelihood of persecution on her.
Excuse me, that Hillary was given permission to present her paper at the conference.
Yes, Your Excellency, but that was before the draconian authorities became aware of this highly critical speech she made in Balboa, and that was before they were aware that Hillary had made available to the international media several reports detailing a variety of human rights abuses that had occurred in Draconia.
Madam Agent, suppose that this kind of an action, perhaps not criminal, but was in violation of some law of Draconia. Why should this court be party to helping the Pankhursts evade prosecution in their own country?
Madam Agent, this is not an appellate court from state court decisions on its own internal law application.
Your Excellency, first, Your Excellencies, there is no evidence to indicate that Hillary's actions are in violation of any draconian laws. In any case, Your Excellencies, we submit that the facts relating to the house arrest clearly indicate that the draconian authorities did intend to take some form of persecutory action against Hillary. It cannot be, Your Excellencies, that the draconian laws justify the detention of her husband and the detention of an 8-year-old child for the activities of Hillary. And we submit that in these circumstances, and given the actions of the draconian authorities in searching her house, in seizing her documents, and in placing her family under house arrest for no apparent reason whatsoever.
We don't know from the facts. There could have been a search warrant because during all those years that Hillary had been writing and speaking very forcefully against the draconian government, the government took no action against her. The fact is that the government did permit her to move, to go and present the paper. The government knew that she would be critical. And so based upon all that past record, how is this court to determine that the objective standard that you tell us has been met?
We urge this court to view the actions of the draconian authorities, both their past and their present actions, in their proper context. It is true, Your Excellency, as you have noted, that the draconian authorities have not taken any action against her in the past. However, Your Excellencies, it appears that when Hillary delivered her speech in Balboa, and when she made available these human rights reports, it appears that the draconian authorities are not willing to tolerate her views any longer. This is evidenced by the fact that there was a close temporal proximity between the delivery of a speech and the actions of the draconian authorities. And we submit that in light of this close temporal proximity, the actions of the draconian authorities must have been in response to her speech in Balboa.
But Madam Agent, are you not clearly establishing that causal nexus just because the actions of the draconian government were perhaps almost contemporaneous with the speech does not necessarily give rise to the fact that Draconia did it in persecution and not in prosecution of certain matters?
That is true, Your Excellency, but we submit that the actions of the draconian authorities, that there is no indication that the actions of the draconian authorities were were because of a violation of draconian laws, and that therefore they amounted to acts of prosecution and not acts of persecution.
What do you understand by persecution?
Persecution, Your Excellency. Persecution is traditionally defined as a threat to a person's life or liberty. But state practice shows that lesser acts can amount to acts of persecution in circumstances where there is a reasonable likelihood that that person will be subjected to persecution. And we submit that in this case, Your Excellencies, the actions of the draconian authorities, viewed in their proper context, in light of the fact that they have placed her family under house arrest, although they themselves appear to be guilty of no crime, in light of the fact that Hillary has made available reports to the international media, and in light of the fact that the draconian authorities' actions appear to be in response to the actions of Hillary in Balboa, we urge this court to hold that Hillary does possess a reasonable likelihood of persecution.
But Madam Agent, quite clearly, could it not also be construed that Rousseau Pankhurst and Emily Pankhurst overreacted? It's house arrest. They're in their own house. They can't leave it. What's wrong with that? They have not been jailed. They have not been arrested. They're under house arrest. The draconian authorities have said you may not leave your house. And they overreacted. And now we call it persecution.
You're being protected in their own house.
No, Your Excellency, we submit that the house arrest amounts to a clear deprivation of their liberty, and state practice indicates that when there has been a threat to a person's life or liberty, that threat will give rise to a fear of persecution, and that deprivation of life or liberty is an act of persecution, especially in the absence of any evidence that suggests to the contrary. Your Excellencies, if this court has any doubt as to whether the actions of the draconian authorities were in accordance with their domestic laws, in the absence of any evidence to the contrary, we urge this court to resolve this doubt in favor of the Pankhurst family.
Well, even if we resolve the doubt in favor of the Pankhurst family, Madam Agent, Mr. Rousseau Pankhurst and Emily entered Balboa unlawfully, have stayed there unlawfully, and Ms. Hillary Pankhurst has overstayed her visa. So technically speaking, she is also unlawfully in Balboa. Why should that not be of any material importance in our consideration?
Dealing first with your question with respect to Rousseau and Emily, Your Excellency, we submit that the fact that they have violated Balboan immigration laws does not lead to the conclusion that they are not entitled to refugee status. The predicament most refugees find themselves in is such that they are unable to leave their states of origin lawfully, and to deny these persons refugee status would mean that most refugees who are forced to leave their states of origin in a clandestine manner will not be entitled to refugee status. And this is borne out by the fact that Article 31 of the Refugee Convention expressly states that states should not impose penalties on persons simply because they have entered a state's territory illegally. With respect to Hillary Pankhurst, Your Excellency, we submit that the fact that she has overstayed the terms of her exit visa does not lead to the conclusion that she has violated Balboan immigration laws. There is no fact to indicate that Hillary has overstayed the terms of her entry visa, and this is the fact that Balboan authorities should have regard to. The fact that she may have violated draconian laws does not justify Balboa in treating her as an illegal alien. Your Excellencies, my time is running short. Perhaps I could just briefly summarize my position on the laborians and the issue with respect to transfer. With respect to the laborians, we submit that there is an extended definition in customary international law, namely a definition that includes persons fleeing civil strife and human rights violations. And in this case, because the laborians have fled Laboria for fear that their lives and liberties would be threatened because of civil strife and because of human rights violations.
Excuse me, Agent, what evidence do you invoke as support for that contention that there is an extension of the refugee definition in international law?
We rely on state practice, Your Excellency, and we rely on three forms of state practice. In brief, this will be the practice of the UNHCR. Your Excellency, my time is up.
You may continue.
Thank you, Your Excellency. We rely on the practice of the UNHCR. We rely on the practice of states, and we rely on the fact that there are international instruments which have extended the definition of refugee in international law.
Could you cite an example?
as regards the international instrument, Your Excellency, we would rely on the 1969 Organization of African Unity Convention relating to the specific aspects of refugees. We would also rely on the 1984 Organization of American States Cartagena Declaration. We would also rely on the numerous Council of Europe parliamentary recommendations, which are all to the effect that there is an extended definition in international law.
Within international law or within regional organizations or regional arrangements, can you say that an instrument which is promulgated by regional organizations becomes international law?
Your Excellency, it is true that these are all regional arrangements, but our position is that the practice of states on a regional basis, a consistent practice of states on a regional basis, has resulted in an expanded definition in international law in general. And we would pray and aid the conclusion, or rather the consensus reached at the abortive 1979 conference on territorial asylum. At this conference, Your Excellencies, it is important to note that states agreed that there should be an extension of refugees, of the definition of refugee in international law. We have no further submissions, Your Excellency. Thank you.
May it please the Court, my name is Stephen Donoghue. I appear with my co-agent, Ms. Carolyn Evans, on behalf of the State of Balboa, the respondent in these proceedings. Madam President, Your Excellency, this case raises the question, what obligations Balboa owes to several hundred individuals who are currently detained within its territory. Balboa submits that it has properly exercised its sovereign prerogative in its dealing with these individuals. We therefore ask this Court to grant two declarations. The first and primary declaration we seek is that this Court does not have jurisdiction to hear the claim which Fredonia seeks to bring. The second declaration we seek on an alternative basis, and that is that Balboa has complied with any international obligations it may have, and that the transfer of these individuals is not therefore required. We will make four submissions in support of our request for these two declarations. First, that this case is inadmissible. Second, that the Court does not have jurisdiction. Third, that none of the individuals in question are refugees. And fourth, that their transfer is not required to Fredonia. I will deal with the first two of these points, the admissibility and jurisdictional questions, and will speak for 18 minutes. My co-agent, Ms. Evans, will deal with the third and fourth submissions and will speak for 25 minutes. We reserve 2 minutes for Sarah. Your Excellencies, turning to the admissibility question, it is Balboa's submission that this case is inadmissible for two reasons. First, because Fredonia does not have standing, and second, because Draconia is an indispensable third party. In his absence, this case may not proceed. With respect to standing, Fredonia have acknowledged that the starting rule is that when a state seeks to bring an action on behalf of a group of individuals, it may only do so when those individuals are nationals of that state. This rule is clearly established in the jurisdiction of this Court, for instance in the Notebomb case, the Barcelona Traction case, the second phase of the Southwest Africa case.
Agent, did this Court ever follow the Notebomb case in any of its subsequent pronouncements?
With respect to this nationality rule, it did, Your Excellency, in the Barcelona Traction case, for instance, where it applied that rule into the situation of corporations. It is submitted that Fredonia have sought to draw an exception to this basic starting rule relating to erga omnes obligations. But in our submission, they cannot do so unless they can satisfy this Court of two things. First, that erga omnes obligations do give rise to a right of standing, and second, that there are erga omnes obligations at issue here. Fredonia would dispute both of those propositions. The only authority which has been cited to this Court supporting the view that erga omnes does give rise to a right of standing is the decision of this Court in the Barcelona Traction case, specifically at page 32. While it is true that that passage does recognise a category of obligations owed to the international community as a whole, at page 47 in that judgment, the Court specifically states that there is no right of standing which attaches to these obligations, to general human rights obligations. It would seem, therefore, that the erga omnes category, which are owed to the international community as a whole, cannot be enforced on a bilateral basis before this court. Instead, states should seek collective remedies before collective institutions such as, in this case, perhaps the United Nations High Commissioner for Refugees or the General Assembly itself.
Who could come before the court to invoke erga omnes obligations?
No one, Your Excellency. That the obligations do not give rise to a right of standing.
So that means that we have no power then to permit any party, state, to come before us, not party to a convention, but any state to come before us to invoke that.
To invoke an erga omnes obligation.
Is that your position?
That is our position, subject to one qualification, which is the distinction noted in oral argument before this court in the nuclear test case by New Zealand, which was that erga omnes obligations may be owed only on a collective basis or on what might be termed a sum of bilateral basis. And I would note perhaps the use of force obligation, which is owed to each state individually as well as to the community as a whole. If it was owed bilaterally, then there would be a right of standing. If it was not, then this court is not the appropriate organ to decide those disputes. This has been recognised by the United Nations Special Rapporteur, Reiss, when he noted that if the obligations can properly be said to be owed collectively, then it should be the international community collectively which responds, not one individual state taking that right upon itself.
But isn't the doctrine of state responsibility still is in a pretty murky state by the International Law Commission? Isn't that right?
That is true, Your Excellency, and Fredonia has relied specifically on Article 5.2e of the ILC's draft articles on state responsibility in support for its contention that all human rights obligations are owed erga omnes. We would submit, however, that again, as the Special Rapporteur noted, Article 5.2e is considered to be a development of the current customary position, and indeed that article is coming under some degree of question now. So we would submit that not only do erga omnes not give rise to a generalised right of standing, but there are no erga omnes obligations at issue here, and that we would submit in the terms of the Barcelona traction case itself that it can be inferred that the court was referring only to the category of jus cogens obligations in that case, piracy, slavery, apartheid, racial discrimination, and it has not been alleged that Fredonia is violating any of those obligations. So we would submit that on these bases the claim should be found to be inadmissible before this court.
Mr. Donoghue, you said that the nationality is a critical point for the claimant, for the applicant rather. And yet that point could be cured, could it not, by Fredonia making the Pankhurst and the Laborian Fredonian national?
Perhaps it could, Mr. President. I would point out first that there is no evidence that Fredonia is intending to take that position, nor that Pankhurst would accept it. But even hypothetically, if that was to be the case, the court would then be faced with a situation similar to that which faces in Nottingham, where the individuals had two competing nationalities, and it would then be necessary to investigate who had the best genuine or effective link between those
Nottingham
states.
could be distinguished, however, because in the case of Nottingham, Friedrich Nottingham received his Liechtenstein citizenship pursuant to an application. What I'm referring to is a unilateral act by a state to recognize an individual or a group of individuals as its citizen, or conversely, withdraw citizenship where it might find it appropriate.
We would submit that there would nevertheless be a case where these individuals could then be considered to be both Fredonian and either Draconian or Laborian national, and the court would be faced with a dilemma as to which one of those states was the appropriate state to protect the individuals.
Mr. Agent, did I hear you right that Nottingham was a dual nationality case?
Yes.
What two nationalities?
Guatemalan and Liechtenstein.
Did Guatemala confer nationality on Nottingham?
My recollection
My
is that
recollection is, sitting on this court at that time, that Nottingham had only one nationality, and that was Liechtenstein, and we did not permit Liechtenstein to grant protection to Nottingham against Guatemala. But Guatemala never claimed that Nottingham was their national.
I take your correction, thank you, Your Excellency. Nevertheless, the court did find in that case that the effective link of Mr. Nottingham was with the state of Guatemala, and It is there, which I
With the
think
genuine connection.
the genuine
doctrine.
connection was there, yes. It is submitted that, as a result of that, in the absence of an offer of nationality from Fredonia in this case, that unless the erga omnes link can be established, and we submit it not, this court may not proceed to hear the case. That even if the court rejects that submission, however, that there is a separate ground for inadmissibility, that being the absence of draconians from these proceedings. This court recognised in the monetary gold removed from Rome case in 1940 that when an absent state's interest forms the very subject matter of the claim, that the court may not proceed to hear that case.
Mr. Agent, how do the absent state draconia's interest involve the laborian?
Involves the laborian, Your Excellency.
You said that there's a third party that is not here.
Draconia is the party we would
And
primarily
to
rely on.
whose interest is at stake?
Well, we would submit that given the interpretation which the monetary gold case has received, specifically in this court in the certain phosphate names in the Rue decision, that makes it clear that an absent state's interests are central whenever, as a precondition of deciding this case, it is necessary to find that an absent state has breached international law. Now, we would submit that in this case, in order to find that these individuals are refugees,
These individuals being the painters.
these individuals being painters, that the court would be required to find that Draconia has violated their human rights in the terms in which Fredonia has put this submission. And we would submit that because Draconia is absent from these cases, and because before this court can grant them refugee status, Draconia must be found to have violated international law, that in the terms of the Nauru decision, they are an indispensable third party.
It is specifically mentioned in the statement of facts at paragraph 13 that Draconia has remained silent throughout.
That's correct, Madam President. But this rule, the monetary gold rule, was developed specifically for the case where a state did not exercise its right under Article 62 to intervene. The doctrine was developed in order to protect an absent state which did not choose to submit itself to the jurisdiction of the court. So while Draconia may have been free to intervene, its failure to intervene does not defeat this ground of objection to admissibility.
President, could you cite me some authorities for your proposition that being a party absent would preclude this court from hearing the case?
When the party's interests form the subject matter of the claims, the monetary gold case, the Nicaragua case, and the certain phosphate names in the Nauru case all stand for that proposition. And all of those cases specifically discuss the effect of Article 62 and Article 59 upon this doctrine, and hold that, nevertheless, once the party's interests are sufficiently central, this court cannot proceed.
And in the Nicaragua case, this court decided?
This court decided that there were no absent indispensable third parties, and the same result was reached in the Nauru decision. But the possibility was acknowledged, and indeed in monetary gold, this ground of admissibility was determinative. So it has been relied upon by this court before.
When was monetary gold decided?
In 1952, Your Excellency, some time ago. But the Nauru case was decided in 1992, very recently, and the court affirmed the position there. Your Excellencies, if I might, I would turn to my second primary submission, that this court does not have jurisdiction to hear the case. Fredonia has relied for jurisdiction primarily upon the compulsory jurisdiction of the court under Article 36.2, and they have conceded that Balboa is entitled to invoke via reciprocity the reservations contained in Fredonia's declaration. There are a number of alternative submissions set out at pages 1 to 5 of Balboa's memorial, but I would, if I may, focus upon Fredonia's primary submission concerning the self-judging reservation, the domestic jurisdiction reservation. And that submission is that Balboa's invocation of the reservation conclusively denies this court jurisdiction, that that invocation may not be reviewed and is determinative of the jurisdictional question. Your Excellencies, it is submitted that the court should adopt this conclusive interpretation for three main reasons. First, the wording of the reservation; second, its history; and third, the subsequent interpretation of the provision by this court. If the court looks to the wording of the reservation, it excludes all matters essentially within the national jurisdiction of Balboa, as determined by the government of Balboa. It is submitted that on a prima facie textual reading, the last 7 words, the last clause of this provision, give rise to the view that it is the reserving state itself which is to determine when this reservation does and does not apply. This interpretation is supported by the history of the reservations. a reservation in this form was first drafted by the United States in 1946, the Connolly Reservation. And there, the Senate debates which accompanied the drafting of that reservation, debates which I might have received a great deal of publicity at the time and academic attention since, made it quite clear that the purpose of inserting that last clause as determined by the state or the United States in that case, the purpose of drafting those words was to preclude review by this court. This has been the interpretation reached by every judge of this court ever to have specifically considered the effect of these reservations. And it has been specifically considered in 7 separate opinions before the court. 3 in the Norwegian loans case, those of Judge Laufpat, Gero and Reiss, and 4 in the Interhandel case, Judge Laufpat again, Judges Bender, Amonjugon and President Kleistad. All of those judges have reached the conclusion that this court cannot set aside or review the determination made under the self-judging reservation. And several of those judges, Judge Laufpat and Judge Reid specifically, addressed the question of whether a good faith reservation could be read into the reservation in a manner similar to that contended for by Fredonia, and rejected that view. So there is a unanimous consensus among the judges of this court who have considered the issue that there is no good faith restriction and that an invocation of the reservation is determinative. Your Excellencies, the complication arises from the view of many of those judges just cited, that this reading, this inevitable reading of the reservation gives rise to the invalidity of either the reservation or the declaration as a whole. In our submission, however, the reservation remains valid as it does not conflict with Article 36, subparagraph 6 of this court statute. That is so because...
Excuse me, I'm sorry. Back to your good faith argument. What is your understanding of the expression opportunity to run that?
The underlying obligation of good faith in treaty law. Yes.
Exactly. And these treaties are to be implemented in good faith by all parties. First question, would you consider that to be a rule of equivalent and if so, why would not a similar good faith obligation apply for interpreting optional clauses?
Because, Your Excellency, optional clause declarations are not treaties. And the real question which defines the jurisdiction of this court is the extent to which the states before it have consented to its jurisdiction.
Of course they're not treaties, but they are submitted pursuant to the treaty provisions.
That is correct.
The
And
argument as well be they're part and parcel of the operation of the treaty. And therefore the good faith obligation is indeed executed in its full norm, but it will certainly apply to derivative actions stemming from the withdrawal treaty.
that is the question which was specifically considered, for instance, by Judge Laufpat in Norwegian loans, whether the treaty's good faith rules could be applied. And there he reached the view that they could not, because that would undermine the consensual basis of this court's jurisdiction. That is, that even if the court does find that there is an element of inconsistency with the court statute and the reservations are invalid, the court cannot proceed to exercise jurisdiction by reviewing a determination in good faith or by severing restriction, because to do so would fundamentally change the scope of what has been accepted by a state making the declaration. It changes it from a situation where they are never obliged to come before the court to a situation where they are most definitely obliged to come before the court. And to do that so fundamentally changes the nature of what has been done that those states can no longer be considered to have consented to come before this court. I would remind the court that the court has always been most careful to preserve the consensual basis of its jurisdiction in order to promote compliance with the court's decisions as a mechanism for peaceful settlement. And I would submit that a good faith restriction cannot be so imposed as to do so unfairly places a state under an obligation which it has not agreed to accept. Your Excellencies, my time is limited, so if I might give an overview of our submissions at this point. We submit that the court may not proceed to hear the merits of this case and should grant the first declaration we seek because the case is inadmissible on 2 separate grounds, because there is no erga omnes standing and because Draconia is an absent party, and furthermore, as a totally separate bar to this court proceeding, Balboa has conclusively invoked the self-judging reservation, and as a result, this court does not have the consensual link it requires under Article 36. If the court has nothing further, then that concludes my submission.
Madam President, Your Excellencies, my name is Carolyn Evans and I'm a co-agent for the Respondent State of Balboa. Your Excellencies, refugee flows cause complex economic, political and social problems for countries which take refugees in. Balboa comes to this court and asks it to respect its freedom and sovereign right to give some level of humanitarian aid to the Laborians in its country, while recognising that Balboa must look to the interests of its own citizens and its national security at the same time. To this end, my submission will take two parts. The first, that none of the individuals in this case are entitled to refugee status, and the second, that international law does not require a transfer, both because transfer is an inappropriate remedy in any case, and second, because there are no breaches of international law, and therefore any remedy such as transfer is irrelevant in this case. It is Balboa's primary submission that its determination of refugee status was conclusive. There was no international law to bind Balboa in this case.
Madam Agent, conclusive and not subject to any further review. Is that your position?
That is our position, Your Excellency, at least not subject to any further review in this court, because in our submission there is no internationally defined and determined view of who or what is a refugee.
Is it subject to review in some other court?
Not in this case, unless Balboa happens to be party to some regional arrangement, which there is no evidence of in the
So
facts.
your Minister of Justice has quasi-absolute power to decide the fate of refugees?
Presumably, yes, Your Excellency, but
The determination is totally yours unilaterally with no international community review in what sort of quarters at all. You can treat them the way you want, determining their status the way you want, and nobody else in the international community can do anything about it.
we cannot treat them in any way that we wish to, Your Excellency, as it's clear that there are certain customary international law human rights obligations which do delimit Balboa's range of actions in this case, and it will be my latest submission that we've complied with those. But we can make the determination any way that we want to, because we have not bound ourselves under any of the conventions or treaties under which we could have bound ourselves had we wished to follow the definition in Article 1A2.
You did say that you do look at the convention guidelines to determine your conduct, because you used that your minister did in order to determine their status. Is that right?
The Minister did make that statement, but we submit it as of no binding international legal effect. It cannot change Balboa from a country which does not have obligations under the treaty to a country which is required to uphold and implement those guidelines. This court in the North Sea case at page 25 made clear that when there was a treaty in existence already that a state could merely sign in order to be bound by those obligations, the court should be very reluctant, should indeed have a presumption against a state having become bound in any other way. This distinguishes a case such as the nuclear test case or the Eastern Greenland case, where a statement by a minister was sufficient to bind the parties because there was no pre-existing treaty which they could have become parties to in that case. So in our submission, this unilateral statement is of no legal effect and therefore does not give rise to legally binding obligations.
Agent Evans, you made a statement before that transfer in any event is an inappropriate solution. What do you mean by that, and can you explain the basis for your statement?
Certainly, Your Excellency. This court in the High Della Torre case was faced with the proposition of a state asking for a transfer. It held that it was inappropriate for a court to make such an order because there were a range of solutions to the problem, even if any individual or number of breaches was found in that case. Indeed, in that case, it was found that it was wrongful to be giving it asylum under the treaty. But the court said, without even looking at potential other remedies, when there are more than one remedy, the court should merely say the law has been breached in X, Y, and Z way, and that should be remedied and rectified. Now, were the court to make such a determination in this case under Article 59 of the Statute of Court, obviously Balboa would be bound by it and will comply with it. But we ask this court not to make such a specific and intrusive, in terms of our sovereignty order, which would require us to do something specific with these specific individuals. It does not merely limit our freedom, it limits their freedom in the same way. If Fredonia's concern is genuinely with the individuals and not merely to appear a white knight and crusader in international terms, a far less intrusive order would be appropriate under the circumstances, as it may, for instance, allow these individuals to remain in Balboa closer to their family and friends, which they may wish to do if this court determines that
Ms. Evans,
some of
if I understand the compromise correctly, the intent of your client state is to return the Pankhurst to Laconia and to return the Laborians to Laboria once conditions would permit.
That is
Am I
correct.
to understand your argument at the moment that your client state is willing to keep the Pankhurst and the Laborians in Balboa?
To make clear, Your Excellency, this is our final and alternative argument. If the court does determine, for instance, that Balboa is prohibited from returning these people to their countries of origin, and we'll submit strongly that the court should not find that. But if the court were to find that, then we would submit that a whole range of other options become opened up for the Pankhurst family and the Laborians, and that this court should not limit itself to the very specific option of granting the transfer requested by the applicants in this case.
Pardon me, Agent, could you give us some idea of what those alternatives would be?
Well, certainly, as agents for Balboa have suggested, there are a number of different options for dealing with refugee problems, and one of them may be, under those circumstances, a grant of asylum by Balboa, which may wish to be taken up. It may be a grant of refuge by another closer state, which may be preferable to the individuals. It need not necessarily be a direct and absolute transfer to Fredonia.
Madam Agent, I'm somewhat troubled by that notion because you just told this court that the determination of refugee status is a determination by the state, the authority at that position.
Certainly.
And now what I'm hearing you say is that we have the power to order you to grant asylum to the Laborians and the Pankhurst.
No, that is not our submission, Your Excellency. It is our submission that that is one of a range of alternatives which are available to Balboa in the exercise of its sovereign power. Not that this court may force us to grant asylum. It is quite clear by the history, for instance, on the Declaration on Territorial Asylum, that states have not been prepared to undertake that method of dealing with issues. But it is one of a range of options open. But it would require the court to have taken a number of previous steps, which we urge the court not to take. That is to find that there are international obligations in determining refugee status.
Why does your client state not let the Pankhurst and the Laborians go? They are obviously a burden to your state. Fredonia has declared itself ready, willing, and able to accept them. Why not let them go?
There are two different rationales for the Pankhursts and for the Laborians, if I could deal with each of those in turn. In regards to the Laborians are part of a mass influx. Laboria is a developing nation right next door to Balboa, and it has been involved in civil war for a number of years. Fredonia is prepared to take these couple of hundred Laborians from us, but we submit that Balboa has a right to look to its future national interests and domestic security in anticipating the potential onslaught of refugees from Laboria, which could occur were this court to determine that these people could transfer on to Fredonia. Now, Fredonia has shown itself, has suggested implicitly by its statement that in this one situation it would take on the Laborians, that it is not necessarily willing to take on any future refugees. But Balboa is then left with the problem of an influx of refugees from Laboria, hoping to use this place as transit stop.
In the event Fredonia's government declares itself ready, willing, and able to take additional Laborians, might that aid your client state in the decision to release them?
It may indeed aid our client state, certainly, Your Excellency. We would still submit that if these people entered our borders illegally, Balboa is entitled to detain those people and to treat them in the manner in which we have treated them, and may let them go on to Fredonia, but is not legally obliged to let them take that move.
Agent, how long might it take, assume that in Laboria the problems continue? Are these people to sit indefinitely in your detention centers that you call guest houses?
The refugee hotel, Your Excellency, while modest accommodation under all the circumstances, yes, it may be necessary for those people to stay in those camps for a long time, or in this hotel for a long time. But state practice has shown that this is the way in which states often deal with refugees, and state practice is required in terms of forming customary international law. Now, states such as Australia, Mexico, Malaysia, Indonesia, Hong Kong, a variety of states from all parts of the world and all levels of development do use detention of people, especially people they've determined not to be refugees and to be illegal immigrants, and it can last for many years.
A moment ago you said state may use, treat them any way it pleases the refugees, obviously with those caveats, but they are not refugees according to you, right?
That is correct. They are illegal immigrants, and there is even a wider scope for dealing with illegal immigrants or visa overstayers than there would be had these people a genuine claim for refugee status. But it should be noted that even if they did have a genuine claim for refugee status, the actions of states across the world does suggest that still long periods of detention may be necessary. That is because states wish to retain some control over their sovereign interests and rights in that country. Refugee flows, particularly large refugee flows, can cause a real danger to various societies and can cause immense economic and social burdens. States have to have some latitude to deal with those problems. If I could cite to the court, for instance, the case of India's taking in of almost 12 million refugees during the Bengali War of Independence, some 30% of India's taxes went towards the upkeep of those people. If this court finds that there is an obligation of temporary refuge and of non-refoulement of people in the cases of mass influx, as urged by the agents for Fredonia, then this court could be forcing those type of massive economic burdens and often social disintegration or destruction upon countries which simply cannot bear to have them.
It seems to me, Ms. Evans, what you just said in the last few sentences of your argument seems to argue in favor of releasing the Laborians to the custody of the Fredonians. They are prepared, they have the resources, let them deal with it.
It rather suggests, Your Excellency, that states need to be given a latitude and discretion to deal with the problems as they see best for their state, taking into account all of the circumstances, including who their neighbouring countries are, what they predict likely consequences of actions to be. Now, it appears that Balboa sees the likely consequences of the actions of allowing these people to transfer onto Fredonia, a developed nation where obviously the standard of living may well be better for these few individuals, would cause it significant problems in the future. And in our submission, Balboa is only doing what almost every country dealing with refugee problems is doing. That is looking to its own sovereign interests, as well as its ability to give, in this case, food and shelter to hundreds of Laborians.
You make a persuasive argument, but I am as yet unconvinced. Answer the following question for me, if you might. As between the rights of the individual and the rights of the state, which rights should weigh heavier on the scales of justice?
I would submit that that question cannot be answered in the abstract of all human rights and of all situations. In the case of a refugee flow, we would submit that the rights of the state have to be looked to and very heavily balanced, while not undermining those very basic right to life, freedom of slavery and apartheid, racial discrimination, and so right not to be tortured, which are the rights of all individuals, regardless of how convenient any state may
It
be.
seems to me, however, Madam Agent, that the state of conditions in Laboria, the only thing we're left with are the state of rights of the individuals, namely the Laborians in the custody of your state. Laboria is in
sorry,
a
I
state
don't
of strife and chaos.
It is,
How
yes.
can we speak of state rights when there is hardly any country available anymore?
I'm sorry, Your Excellency, I refer to the rights of Balboa to develop a plan to deal with the problem that it has with its next door neighbour being a developing country with massive civil strife and difficulties there. This is a problem faced by countries all over the world. The countries of Southeast Asia are still trying to deal with the consequences of the massive outflow from Indochina and have dealt with them in a variety of ways and have expected the world to respect the wide latitude that they have taken in terms of treatment of the refugees and in terms, in some cases even, of returning those people to their country of origin.
And in the case of Thailand and Hong Kong, for example, Vietnamese refugees, so-called boat people, which refers to their mode of transportation, more than anything else, have been pushed back into the high seas.
They have.
And both countries have been subjected to severe criticism in international law, which has led to a change in their policy habits.
10 days ago, Your Excellency, Thailand returned several thousand people across the border into Cambodia, claiming that they had not invited these people, and despite the fact that they claimed refugee status, Thailand did not want to be hospitable to them. Now, there has been international criticism, but there has also been sympathy from the surrounding states who actually understand the problem, who are not standing at a distance, imposing what are often developing world or Western norms upon these countries trying to deal with the realities of the situation.
Madam Agent, there's no Western norms on it, are there? Because what you really have said in the last few minutes gives me an indication that you have made a very, very strong case for community action and not for unbridled state sovereignty in this area.
We would submit that, of course, community action is one of the methods of dealing with refugee problems and has been forthcoming in limited amounts from more developed nations. Countries like Fredonia, who put quotas on, who say we will take a small percentage of your problem, but we'll leave you to deal with the rest of your problem, which is what we submit that Fredonia would be doing in this case.
That seems like burden sharing. It seems like a good idea.
Burden sharing may generally seem certainly to have some elements which are conducive to being a good idea, yes, but in this case, it is the nations of first asylum, the nations into which these people have entered, who have to deal with the problem, and that they have to be allowed quite a deal of sovereign interest in determining that. Now, if Fredonia were to say it would take on everybody from Laboria, for instance, that might change the situation quite dramatically. If we understood that Balboa would only be a very, very temporary asylum for these people, that might be different. But nobody has been prepared to make that statement. And Balboa is stuck in the same position that so many nations across the world are, that is, dealing with a refugee problem, with norms being imposed on them from the outside by countries who aren't prepared to genuinely take on the burden of sharing refugees.
Pardon me, Evans. You made a statement before. You've been using the term refugee very freely, but then you made a statement saying that these people are really illegal aliens or illegal immigrants. First of all, what's the difference? And second of all, if we were to grant that allegation on your part, how would that change your position?
The difference we would submit in this case is that, well, there is essentially no difference because all of these, except for Hilary Pankhurst, all of these people have entered our borders illegally. As we said, there is no customary international norm requiring any particular test to be applied by the Balboan government. A refugee is anyone that the Balboan government recognises as a refugee and grants refugee status to. That is none of the people in this case.
But notwithstanding that, you have applied the criteria laid down in the convention, have you not?
We have, and
you have concluded that Hillary and the others have failed to satisfy that. And once you've answered my co-judge's question, I would be interested in you looking at the position of Hillary.
Certainly. In terms of the change of position that this might require of Balboa, there is even stronger authority to say, for instance, that the detention of people who have been determined to be illegal immigrants properly, if there is international law, under international law, that those people may well be detained and returned to their countries of origin. This is even far more common practice, even for states who have reasonably good records in human rights and refugee law, to take such action for illegal immigrants. But we submit, even if these people did fall into the category of refugee, particularly of temporary refugee, that the behaviour which Balboa has shown is still the sort of behaviour that states all over the world trying to deal with refugee problems show, and that therefore there has been no breach of customary law. And if I could turn to your question, Madam President, that is, if this court does determine that there was an obligation to use the convention criteria in this case, Balboa would submit that it has been done correctly. Agents for Fredonia did not press the Laborians as falling within the definition under the convention, and unless the court wishes to hear argument on that, I would therefore not address that issue. It is their submission that Hilary Pankhurst is entitled to refugee status because she has a well-founded fear of persecution on the basis of her political opinion. But we would remind the court of the context in which this action is taking place. Draconia is a developed democratic country, certainly undergoing some problems at the moment, but it is still a democratic country. It has allowed Hilary to speak in the past. Indeed, she has gained an international reputation as a lawyer, which has been some form of protection for her, and which could only have been heightened by her speech in Balboa, where the international spotlight has focused upon her. In that context, the only thing which would disturb the presumption that the Draconian government will continue to treat her as they have treated her before, she may be annoying, but she's certainly not being persecuted, are two actions. One is the searching of the house, and the other is a house arrest of her husband and child. Now, both of those actions can be perfectly legitimate under the laws of all types of democratic human rights respecting countries. They can be actions taken for a reason by police, they can be done under warrant. Now, there's no evidence here, for instance, of any crime, but the Balboan government is holding Hilary Pankhurst with an attempt to negotiate her return to the Draconian government.
There's evidence, but there is evidence that soon after Hilary Pankhurst gave her speech in your client's state convention, her home was intruded and her family has been put under house arrest. Why is that not persecution?
Firstly, that is not persecution because the coincidence of timing, and we would submit that if the burden is clearly on the applicant to show refugee status, the mere coincidence of timing is not sufficient when the actions undertaken are ones which may well be perfectly permissible actions. It should be noted that a duplicate passport was found during the search of the house. And under the laws of some nations, it may be quite legitimate to prohibit people from having such a passport, and that may well be a reason for the search to have taken place in the first place. Balboa at least has an obligation to look towards its relationship with Draconia and not presuppose that Draconia has used its laws in an arbitrary, illegal or criminal manner to persecute these people. And the absence of Draconia from this claim needs to be reiterated again, that it certainly has evidence, or could have evidence, which could be important and determinative in this claim.
Agent, I had a question about the board.
Certainly.
Just if you could help me clarify my own mind about your government's position. You just indicated that Laboria was in a state of chaos and strife, and the facts indicate that the Laborians were not returned because the appropriate government agencies responsible for undertaking their return were not apparently functioning for it. Therefore, the government there was not functioning for the purpose of returning the board. But your co-agent has argued that this entire case should be declared inadmissible because Laboria isn't here.
I don't think my co-agent did argue that with respect to...
It's a question of the jurisdiction. The case is inadmissible as the legal position of Laboria and Cohen, neither opinion of the court forms the subject matter of the case. So is your government's position for some purposes, agencies of the government of Laboria continue to function, that is, they should be here, and for other purposes they do not?
I'm sorry, yes, in terms of our memorials, that position is certainly argued. No, it is our continuing submission that there are no agencies in Laboria at this point who can be responsible for taking care of these people. But in terms of the submission which can sometimes that may be made by Fredonia, that is that these people, that the Laborians have become stateless, or that we have forced statelessness upon the Laborians by our action, and that suggested by the compromise, we would submit that to make such a determination would be to determine that Laboria has ceased to exist as a state in some manner, or to implicate the relationship between the Laborians and the state of Laboria, and that it would be inappropriate to take that action were Laboria not present. But as that has not been pushed by agents for Fredonia, we would no longer emphasise the argument that Laboria is an indispensable third party, while continuing to reiterate that Draconia is.
Agent, I would like you to just explain to us what effect you think that the fact that Balboa, as a signatory to the Convention on the Rights of the Child, has to do with the placement of the children in homes where no one speaks the language of the children.
Balboa is, as Your Excellency notes, a signatory and not a party to the Convention on the Rights of the Child. Under Article 18 of the Vienna Convention on the Law of Treaties, Balboa therefore has an obligation to do nothing which would frustrate the objects and purposes of the treaty. Balboa has taken an action in this case to separate the family, the husband and wife, and the child Emily and other Laborian children from their parents. Under the circumstances when we submit that detention is appropriate in this case, and the argument regarding rights of the child presupposes the arguments regarding detention, in a case where detention is permissible and allowable under domestic law and proper at international law, then it is certainly not a frustration of the objects and purposes of the Convention to place the children in households where they can live far more normal lives than they would be able to in the refugee hotel. Now, Article 3 of the Convention on the Rights of the Child suggests that the best interests of the children are paramount in cases such as these. We can see that it is somewhat a tight call in such a situation as to whether it would have been better to place Emily and other children with their mothers in a hotel where Fredonia has admitted the situation is not proper for adults, where it's admitted it is legal, but certainly not ideal for children, and placing them with Balboan families where they can live far more normal lives. Indeed, Article 9 of the Convention on the Rights of the Child suggests that in cases of detention, children may well have to be taken from their parents.
What about the fact, Article 12, saying that a child, and certainly she's old enough, at age 8, has a right to be heard or to take part and have some kind of determination as to her circumstances?
Well, firstly, I would submit that that specific article, given its fairly specific nature, is not part of the objects and purposes, and therefore our action has not breached any of our international legal obligations in its frustration. But secondly, in this sort of circumstance, it may be one where the best interests of the child are not to be asked to give an opinion, to force a child into a position where they are asked to choose between staying with one parent in a detention centre and being perceived to abandon a parent may well not be in the best interest of a child, especially as an 8-year-old child is a reasonably young child.
Yes, Evans, it seems to me
My
your-
time is up, Your Excellency. Can I answer?
Just answer this last
Certainly.
question. It seems to me your client state has gone beyond just placing Emily Pinehurst with a foster family, if you will. It has made the child a ward of the state, and that's a rather severe step. I wonder what your views are on that point. On that point, excuse me.
Under the circumstances, we submit that this was not an action which would frustrate the objects and purposes of the Convention. By making these children wards of the state, is given the state some ability to ensure that they are protected in the best way possible. Their parents are in detention and unable to take the steps of protection and care which parents may take under normal circumstances or foster parents under other circumstances. And in our submission, this creation of a wardship of the state is not sufficient to breach those objects and purposes. Were the court to determine that it was, it need merely make an order to that extent and not an order that requires the transfer of the whole family. The issues as to the rights of the child do not impact on transfer. Given the expiration of my time.
I have one question.
Certainly.
There is a question arising from page 14 of your submission. You say that there is no evidence that Hilary is being persecuted on the basis of her sex. You're inferring that if there was such evidence, then there might be a case for granting her refugee status. I understand that, or my understanding is, that of course the definition contained in the Refugee Convention is gender neutral.
We do not concede that were there persecution on the their persecution on the basis of sex, that would be sufficient. But some courts have begun to move towards a position that sex, for instance, may fall within social group in certain limited circumstances. United States America court quite recently determined that, for instance, returning female children to a country where they may be subject to female circumcision may be sufficient persecution to form persecution on the basis of sex for the term of the convention. But there is no evidence of it here, and in that case, the whole issue as to whether it is part of a social group or not becomes irrelevant in our submission. If there are no further questions, that concludes the submissions for the agents for today. Balboa. Your Excellencies, the heart of this dispute concerns the plight of a group of persons who are being detained in Balboa. The applicant state has argued that these persons are refugees, that they were entitled to certain rights as refugees, that Balboa was under an obligation to protect these rights, that Balboa violated these rights, and that therefore that international law requires the transfer of these persons to Fredonia in these circumstances. The gist of the respondent state's case today amounts to a submission that they are entitled to detain these persons for an indefinite period of time, that they are entitled to separate the husbands and wives, that they are entitled to take the children away from the parents and place them in an alien environment. And all these, Your Excellencies, that they are entitled to do this when there is a third state like Fredonia which is willing and able to grant them permanent asylum. And they have urged this court not to impose an obligation to transfer the Pankhursts and the Laborans to Fredonia on two grounds. First, Your Excellencies, they have argued that a transfer is inappropriate, and secondly, that there is no obligation to transfer. Dealing first with the arguments with respect to why a transfer is inappropriate, they have conceded that there are essentially three solutions to this problem: voluntary repatriation, permanent asylum in the receiving state, and third state resettlement. Voluntary repatriation is not available because this would amount to a violation of the principle of non-refoulement. Permanent asylum is not available in this case, Your Excellencies, because as the respondent state has submitted to this court cannot impose an obligation on Balboa to grant asylum to these persons. And there is no indication that Balboa wants or intends to grant these persons permanent asylum. In these circumstances, Your Excellencies, the only available solution is third state resettlement, and Fredonia is here today to grant these persons precisely this solution. And
Madam Agent, it seems to me also that your opponent said if the third part lies that you just illustrated, they would be further aided if there was a national link between the persons to be released and Fredonia. Setting aside for a moment that we can overcome a not-a-born problem, they say it would be, they're not Fredonian citizens. Why don't you make them Fredonian citizens?
Your Excellencies, as my co-agent has indicated, we have no instructions on this point whether Fredonia is willing to grant these persons nationality. It is possible on the fact that Fredonia will probably grant these persons nationality, given the fact that Fredonia is willing to grant them permanent asylum. It is true if Fredonia had granted these persons nationality, Fredonia may possess a greater link, but our submission is that Balboa has violated erga omnes obligations, and that a violation of these obligations entitles Fredonia to come before this court and seek a declaration.
Are you able, as a state, to grant and confer nationality upon people who have absolutely no connection with you and are living in another state?
Yes, Your Excellency, Fredonia is entitled to do this under international law. There is no obligation. Your Excellency, my time is up. May I just answer your question? There is no obligation. There's no requirement in international law.
There has to be no linkage with you at all, no genuine connection with the state at all. They are living in another country, and you simply confer nationality on everyone who is 7'2" around the world to come and play basketball for you. Can you do that?
No, Your Excellency. Our position is that the genuine link in this case is satisfied and this can be found in the fact that Fredonia is willing to grant them permanent asylum, and that therefore the genuine link is satisfied, and it is not as if Fredonia is granting nationality to everyone else in the world, Your Excellency. We have no further submissions. Thank you.
Madam President, Your Excellency, Balboa makes just one point in rebuttal relating to the transfer issue. It is submitted that there are many more than 3 possible outcomes to this case, and that the many permutations which exist depend upon the precise finding which this court chooses to make in this case. It has been our submission that we have not violated any international obligations, and that all this court need do is grant a declaration to that effect. But even if it does find that Balboa has violated one of many of the alleged obligations at its hand, that does not mean that a transfer is the appropriate remedy. And this was held by the court in the Higher Della Torre case to be the situation, that the court should try to find in our submission the remedy which least infringes the sovereignty of Balboa as a sovereign state playing its part in the world community. It is our submission that Fredonia cannot say that they are the only state to which these individuals can be transferred. Indeed, there is the precise contention and future obligations of Fredonia in this context are unclear, given that the Fredonian state has not been willing, as of yet, to grant nationality to these individuals. Indeed, we would suggest that it is an inference which may be available to this court, that if they did intend to grant nationality, they would have done so before they initiated this claim, as to do so would have greatly strengthened their ability to successfully prosecute the case before this court. Your Excellencies, we ask this court to remember and to try to properly balance Balboa's minimal and limited human rights obligations with respect to these individuals with their state sovereignty and their ability to cope with the refugee flows with which they must deal.
Mr. Donahue, it seems to me that the converse argument also is being made by your opponent, namely that the refugees should be treated as some kind of a stateless person, and that in fact gives them the right to take up that claim because there is nobody else to stand up in the world community and speak for them.
Regretfully, Mr. President, may I answer the question? The international community has recognised that stateless persons are to some extent unprotected in international law. The fact that someone is stateless does not give every state in the international community a right to act on their behalf. Instead, the international community may better act collectively through the United Nations Human Rights Commission or the United Nations High Commissioner for Refugees to protect the rights of these individuals. The court has not accepted a necessity type argument which states that simply because an individual does not have a protecting state, it may look to any other state to protect its rights.
As a collective organ, the International Court of Justice is part of the United Nations, is it not?
That is true, Your Excellency, but it is not an organ which was intended to act in a proactive way on the international community. It is a dispute resolution forum. Your Excellencies, if the court has nothing further, then that concludes Balboa's
Can
submission.
I just ask you one question?
Parliamentary.
You deny the existence of the principle of non-lethal, your government.
Your Excellency, we submit as our primary submission that state practice is so inconsistent in terms of violations of the norm of non-refoulement that, yes, it does not bind Balboa in this case. The Article 33 of the Refugee Convention has not, in our submission, become customary international law. That argument is set out in the memorial.
But you are willing to rely on the defence, Article 33.2, for your non-compliance with Article 33.1.
If Article 33.1 was to have been considered to become custom, then it is submitted that Article 33.2 must have accompanied it into customary international law, that states should not have a higher obligation under custom than they would have if they had signed the treaty, and that the exception to the proposed rule should be available to Balboa if it is to be bound by that rule, which we submit it is not. Thank you.
I'd like one last clarification, and that is, you have repeatedly said, well, there are many other solutions. As I understand it, you're asking us to agree that Balboa has absolute power over these individuals within the state to either send them back to the countries that they came from, or what? And you say there are many other possibilities. If you're asking us to make this decision on your behalf, what are the other possibilities you may have hope that you will provide to these people?
Well, Your Excellency, it would depend on exactly what breaches were found against Balboa, but one obvious possibility is to set out the requirements which bind Balboa at international law and to tell it to comply with them. And Balboa might therefore make another determination, investigate the refugee status of these individuals again. Another possibility might be that another state on the international community would wish to offer these people nationality, and that they might prefer full nationality rights over the permanent asylum which has been granted. We don't know in these situations, and granting a transfer order too greatly restricts the options of these individuals.
President, do tell your government to comply with international law, will you?
If this court tells them so, then I have no doubt that the government will comply. Thank you.
The court will now adjourn, and we will retire to make our deliberations. Thanks. Well, ladies and gentlemen, as you can see, we are a somewhat depleted bench, and we are going to be further depleted. So Professor Nanda is going to say a few words, and then he is going to leave for Dallas Airport.
Getting plane. Thank you. My colleague Larry Johnson wanted me to tell you that he enjoyed being with you, he enjoyed listening to you, and he had to leave in order to get to his plane. And that's exactly what I'm going to do. But at this stage, after having gone through round after round, you don't really need my comments. My comments are simple. You are wonderful. I wish that the same kind of caliber, the same kind of talents would be available to our own courts day after day. You are sharp, you are precise, you are responsive, and most of the time you are not simply articulate but eloquent. I wish you the very best. I think as the court gives you a unanimous judgment, you'll be pleased with it. Obviously, this is adjudication. Not everyone wins, but at the same time, I simply want you to know that you are extraordinary in every possible way that I can think of. I wish you again the very, very best, and my apologies that I've got to leave you. Thank you very much.
I would just like to say this is my first experience as a judge. And so I jumped in at the top, and it was terribly intense for me. It was also very exciting. I was very, very impressed with the quality. And it was, as I'm sure you probably realize, it was all a very, very difficult decision for us. Each of you did very well. I'm sure you must have been nervous. You managed to hide it from us quite nicely, and I think that speaks very highly for you. You were quick in your responses. We threw terribly difficult questions at you, trying our best to find ways to make you show your stuff, and I think you did that, and I want to congratulate all of you.
I am uncertain that there is all that much that I can add to what my colleagues on the bench have already said. I was equally impressed and at times overwhelmed by the amount of preparation that must have gone into your work, both in terms of the memorials as well as your arguments. And you gave us the joy of listening to the arguments, and I think the corollary obverse of that coin is the misery of having to choose. And that's part and parcel of what judging is all about. So as we had chosen and as we have judged, I hope that you walk away from the competition not in the context of who has advanced and who is left behind, if anyone is left behind, but from the point that just to get to this point, you have overcome extraordinary effort and you've put in enormous amount of work. So there is really, in my mind's eye, no quote-unquote winner and no quote-unquote loser. Both teams win and both teams advance. And the only other request I have is as you return to your respective jurisdictions and your home countries, that you keep in mind that there are hundreds upon hundreds of thousands of people in this world who, not unlike the Pankhursts and the Laborians, do not have a voice for themselves. And I express a sincere hope that in your professional life, you might find an opportunity to give them the voice that is so desperately needed in today's day and age, so that we might have law and order on an international scale and pursue the affairs of humankind on this planet in an orderly fashion.
Two themes that in fact Morad has introduced. As probably most of you are aware, I have a personal interest in today's round. And you know, I leave it with still a tinge of disappointment because I do not know the fate of Hillary, Emily, Rousseau and the Laborians. However, I hope their fate is not that of being relegated to the back of a Jessup drawer or a Jessup file. Because as my colleague has said, the problem of refugees is one which is confronting the contemporary international community and is one which has to be tackled. So if the fate of Hillary and others is the back of the drawer, then I hope that the issues raised do not remain at the back of the drawer. And also, my colleagues have said that it is difficult to choose. And in a sense, we have two winners in that you are the winning teams that have advanced to the final. But I hope that all of you here today who have participated in this competition will go away feeling that you have been a winner, because to come to Washington means that you have won through the national round. And you know, although no one is going to deny the winning team and the team that comes second their moment of glory, winning is a passing pleasure. And I hope that they, like you, or that all of you who have participated, will take away benefits which endure, such as an increased knowledge of international law, developed research skills, and friendships forged which will transcend time and geography. That, however, is enough. I think the interests of natural justice demand that I pull you all out of your suspense. We have two awards, the award for the winning oralist and, of course, the award for the winning team. The winner of the oralist competition goes to Ms. Evans. pluralist for the respondent. However, on the basis of what has been said by my colleagues, and because of the team effort which was displayed, the recipients of the 1994 Jessup International Moot Court Competition Trophy is the team representing Singapore. Ladies and gentlemen, for the second time today, can the court be adjourned and go into recess so that we can come off the podium and the way be cleared for the presentation ceremony? Thank you.